Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doug Higgins.
And I'm Doreen.
Welcome to Hull on Estates. You're listening to episode 706. Doreen, today we're going to be discussing the decision of Gomes and Silva. And this is a recent decision from the Ontario Court of Appeal. Recently, a lot of our podcast materials, as well as some of our blogs, we've been talking about the competing limitation periods from different statutory sources in Ontario. And I know you have some thoughts on this decision as it relates to that.
Yeah. So, Doug, maybe you can tell us a bit about and name the case we had been talking about.
Right. So we've been speaking at length recently about the Cullinan decision. And this is from the Ontario Court of Appeal as well. This decision actually followed that quite shortly. This is a more recent decision. And it's substantially on the same topic, but there is a bit of a twist in terms of how the principles of law are being applied here. And Doreen, I know you know the facts of this case a little bit better. Would you be able to give our listeners a bit of a sense of how this case came forward?
Yeah. So Gomes and De Silva, like you said, was a recent decision of the Court of Appeal. It came out after the Cullinan decision. Ian and I were really lucky and grateful to the Toronto Lawyers Association for the opportunity to intervene on the Toronto Lawyers Association's behalf in the Cullinan decision and bring forward those arguments where there are competing arguments as to what limitation periods apply where a party is advancing a equitable trust claim with respect to real property and the players involved as it relates to the ownership and use and who lived in that property. Some of those people happen to be dead, and at that point does the Trustee Act apply, which has a 2-year limitation period from the date of death, or is it the Real Properties Limitations Act, which gives you 10 years from when that right first accrues to you or when you are first dispossessed? This decision, Gomes, the one that follows Kulnick, does not refer to the Trustee Act. It only decides this case based on the Real Properties Limitations Act. And I really want to start unpacking the reasons why. Why did the court at both the lower level and at the Court of Appeal level, when it was asked to consider, is this even a viable claim? Is this claim statute barred? Why did they only resort to the Real Properties Limitations Act? That's what I want to talk about today. And we have a bit of time. I want to talk about like the Evidence Act issue in this case as well, which I actually found to be like super fascinating. The facts in Gomes and De Silva starts with this property. It's all about this property. I'm going to call it a house. It may or may not actually be a house at the end of the day, but I'm just going to call it, for the sake of this podcast, a house. Yeah. Sometimes it would be a cottage, sometimes it could be a piece of land. I'm going to call it a house. So this family, mom and dad, has 4 kids. In 1974, mom and dad and one of the kids, the appellant, so I'm going to call him the appellant, his name is Victor, they buy this property together. And how the ownership of this house was acquired by these 3 people, mom, dad, and one of the kids, the appellant, is on a 50-50 basis as tenants in common, but mom and dad shared 50% as joint tenants. The appellant had his own 50%. Now, dad dies in 1996. So what happens when a joint tenant dies? The surviving joint tenant gets the full share. So dad dies, mom gets the full 50% that she used to share with dad. So then, as of 1996, after dad's death, it's 50% mom, 50% appellant, the one kid, Victor. Tenants in common.
And just
So
for our
no right
listeners,
of survivorship anymore.
understanding, Doreen, at this stage, were there any conversations about how the property was to be owned, or did the parties just proceed after Dad's passing?
Not that I'm aware of. I'm not aware from the facts that there were any discussions after Dad's death. But that's a really good question if you get a file like this to really probe your clients about. Because it usually is at these junctures that people like tend to like revisit ownership, right? Like something had to be done for mom to like register herself on title to have like that full 50%. So maybe conversations were had at that point in time. That's really good evidence to get out of your clients, or at least to like ask the other side about at a cross-examination. This one I can't tell.
For sure.
No, or
So,
not that I'm aware of from like my reading of the lower court decision. I'm gonna fast forward because
okay.
I want to take us factually all the way to the point where like this application was actually started before I go back and start filling in some of these details. So, okay, where was I? 1996 is now 50 mom, 50 appellant, tenants in common. 2012, what mom decides to do with the 50% that she has on title is she decides to change that and add all of her kids to this house. And what she does with the 50% is she creates a joint tenancy with herself, the appellant, and the three other kids. So you have 5 people now as joint tenants of that 50%, and Victor still has his 50%. Mom then dies in 2019. So the surviving joint tenants of that 50% is now split equally amongst the 4 kids, 12.5% each. The appellant still has his 50%. And at some point after that, the siblings all decided to sever the joint tenancy and just all be tenants in common. And so that's why in the reasons it says after death, the appellant ends up having 62.5%. He ends up getting 12.5 points more, and his 3 siblings each have 12.5%. That is the ownership on title that you see at the time the actions were actually commenced.
So I guess the roots of the conflict here, he has this controlling 62.5% in the home. The remaining 3, they have the 37.5. Now, he's living in the house, if I remember, or he wanted to continue to possess it. And they wanted to essentially dissolve their interest in the property.
Yeah, they
So
wanted to partition and sell.
yeah.
Yep. They brought an application for partition and sale. And what did the appellant do? The appellant brought his own like counter proceeding. He wanted the court to order that he is in fact 100% owner of this property. And the reason why he says that has to do with how it was originally purchased in the first place. So he wants to take it and make it an issue back to 1974 and said that actually, even at the time of purchase, my parents were only 50% on title on a resulting trust. For me, I'm actually 100% beneficial owner this whole time. So that's a long time ago. 1974 is a long time ago. This proceeding, well, would have been commenced after mom died in 2019. The court then like had to hear all of this evidence about what happened in like 1974, what happened like after dad died and so forth, like all the way up until 2019. What the court ultimately found with respect to the limitations issue and what they ended up hanging their hat on was something that happened in 2008. So in 2008, dad is already dead. The 2008 ownership on title legally is 50% mom, 50% appellant. Appellant writes to mom through a lawyer and says, I need consent to mortgage my like this 50% of the property that you have. Mom says, no. I don't agree to do that. What I think we should do is either you buy me out or I buy you out, or we just sell the property and split the proceeds 50-50. Now, when the appellant wrote to his mom in 2008, he says, if you don't give your consent, I'm going to have to take legal action accordingly. He never did that. He never took legal action accordingly like he said he would. And his mom already told him, also through lawyers, that this is my 50%. You need to buy me out of this. I don't agree with you that somehow you just like totally own this property. So that's why the court thought like you for sure knew by 2008 you have a problem here. And at that point, mom is still alive, he's still alive, and that is where the limitations clock was found to start running for him. The 10 years under the Real Properties Limitations Act was going. And it was found to end in 2018, the year before mom died. And so that's where the Trustee Act wasn't found to be applicable here, why it wasn't argued, because it actually already ended before the death of the person who conveyed the interest to the siblings in the first place. Like, if you want to go that far back, the court is looking at, well, when should you actually have raised your hand? Now you're kind of revisiting an issue that you had with your mother on the people that ended up getting the property at the end of the day. And it's not even by way of like a transfer through mom's will. It was also like a transaction in 2012. In 2012, the appellant was happy to get go on mom's 50% as a joint tenant too, along with the rest of his siblings. And I guess he didn't do anything about it then either.
So Doreen, just
Um,
for our listeners' understanding, I guess one of the questions that some people might have is, okay, we have this 2-year period under Section 38 of the Trustees Act. But on the books in Ontario, we still have the 10-year period in which the Real Properties Limitations Act is still in play. And so I guess had things played out differently in this scenario, um, would if he had brought, for example, if he had never spoken to her about the ownership structure of the property, say until 2015, would that still enable to him in these particular circumstances? Could he have had that claim still valid until 2025, for example?
so in my view, from my interpretation of Colonic, the answer would be no, because then the Trustee Act would kick in. So like if, yeah, like you said, he didn't write that lawyer's letter asking his mom about the mortgage until 2015. She still dies in this scenario in 2019. So 2015, counting forward 10 years, is 2025. She dies in the middle of this period. Because of her death, because of the Trustee Act, because of the Kolnick decision, that's where the Trustee Act will work to truncate and shorten a limitation period so that it doesn't go beyond 2 years from death. It doesn't go all the way to 2025, which would have been from 2019, given this person 6 years from death. And that's all the Trustee Act really does. It, where it applies, could shorten a limitation period. It also never extends limitation periods. So in a scenario where, that letter was written in 2009, right?
Yeah,
Mom still
in
dies
theory,
in
that kind of
2019.
fits.
Yeah. Mom still dies in 2019. Letter letter was written in June 2009. Mom dies May 2019. It's really you still have just that one more month, right?
Mhm.
10 years from June 2009. It's not like then the Trustee Act gives you an extra 2 years. And that's how the Trustee Act works is really well covered in the Kolnick decision. That's how the Supreme Court of Canada has interpreted statutes like the Trustee Act. It's in a case called Ryan and Moore. as well as Cameron Morgan from the Ontario Court of Appeal. Now, I think we've gone on for quite some time now. The last thing I want to mention about Gomes and De Silva is that I've never seen a Section 13 Evidence Act corroboration requirement talk about the heirs, next of kin, and assigns of a deceased person. It's usually people use it when you sue an estate, you have to sue the estate trustee. So a lot of times it's just applies to actions against executors, right? The executors of a deceased person. Here it was still found to apply for all the reasons why we have Section 13 in the first place, right? If you're going to say all these things about these dead owners of a property, these dead co-owners all the way back from 1976, this is where it's really important for the court to actually have reliable evidence. Because if you're the last one standing, the only person alive to give evidence in court, how can the court really tell that you're telling the truth when it doesn't have the opposite side of an argument and evidence that could be presented from these deceased people? We don't have Ouija boards. It's not a TV show. But like I said from the top, it's not an action against the estate trustees of Mom's estate. It's about the people who actually received an ownership interest in the property through this now deceased person, the mom. That's why they ended up getting sued, but at the end of the day, it was about Mom. So this is where the assigns came in. The court read all these words, found assigns of a dead person applies to the siblings in this case. And so this appellant was still had to do the requirement. Now, this isn't always going to be the case. It's not that every case where, what did a dead person say or do comes into issue will trigger Section 13. It's also because this one, the relief sought, is specific about this dead person's conduct. And what the deal was between this dead person and the person suing. So that's how it's found to apply. Okay, so I think that's good to conclude, unless you have any more questions for me, Doug.
No,
I hope I explained this case okay.
You did, yeah. And you know what? I mean, I think it's important just for all of our listeners to really be very deliberate in how we read into these limitation periods. In particular, I think we need to give a lot of thought to the sequence of events that takes place. But in any case, I suppose that concludes our podcast. Until next time, we really want to thank you for listening. I'm Doug Higgins.
I'm Doreen.
And should you have any questions, please feel free to email us at info@hullandhull.com or contact us through the contact page on our website.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.